Hi there and welcome. I'm Brian Phillips. I'm the Chief Communications Officer here at the Texas Public Policy Foundation. And I'm sitting here with two of our experts here at TPPF. And you're watching Deja Vu all over again, Obamacare at the Supreme Court. Earlier today, we heard oral argument from both sides litigating the big issues in Obamacare. I'm sitting here directly to my right is Rob Henneke. He is our general counsel here at the Texas Public Policy, but he's also the lead counsel for the individual plaintiffs who took the case or who sued on behalf of millions of Americans who have been negatively affected by Obamacare. And that's how the case ended up at the Supreme Court is with Rob's clients. I'm also sitting here with our public policy expert, our healthcare expert, Dave Balot, who's the director of our Right on Healthcare campaign. So I want to talk a little bit about the case. We just heard oral argument. Rob, you're the lawyer in the bunch. Tell us a little bit about what you heard in your analysis of how the litigants did, but also what you heard from the justices.
So it's really going to come down to how much of the Affordable Care Act is struck down by the court. Some things that struck me, the state of California and the Democrat-controlled House of Representatives really made a hard push saying that my clients and the state of Texas didn't even have a basis to be in court in the first place. That just really seemed to go nowhere with the justices. And that didn't surprise me because really this is the third case involving a challenge to the Affordable Care Act to get to the Supreme Court. And so the justices have been here before, and these procedural arguments that the other side was making, really seemed to go nowhere. Mm-hmm. The other thing too was that, the court is still bound by its analysis in the first Supreme Court case that said, look, by itself, the individual mandate is a command for people to buy health insurance, and that command is unconstitutional if you don't have something like a tax to be able to lump it together with. And we know that Congress repealed that tax in 2017. That was what was allowed to justify Obamacare back in 2012. So really it comes down to severability, which is the doctrine of when you have a piece of a law that's unconstitutional, how much of the law that's tied to that has to be struck down. One of the points that came up several times during today's argument was just how unique the Affordable Care Act was. I mean, it really is its own creature in that Congress passed this 900-page bill that just basically lumped in every kind of, special interest provision that they needed at the time to be able to buy enough support to pass the law. Now, our main focus has been on Title I, which is the part of the law that really imposes the burdensome regulations on individuals. It's what has driven up health costs. It's what's made healthcare unaffordable, is what has really caused millions of Americans today to be uninsured. It's the focus of our case, the individual mandate that commands my client to have to buy health insurance. And I think our side made a really strong case today that, because the court is supposed to be bound by the text of the statute, at a very minimum, the court has to strike down the key provisions in Title I, which are really what creates the burdensome regulations on people and prevents them from having control and empowerment over their healthcare choices.
And we'll get to what you think the justices laid out, kind of read the tea leaves a little bit. But Dave, I want to kick it to you. That was a 900-page bill, as you mentioned, that we all had to pass before we knew what was in it. Right. Of course, famously said by Nancy Pelosi. What's your key takeaways from today?
The constitutionality of the individual mandate, I think, is at risk, and that's a good thing. Anytime that we have the ability to uphold and defend the Constitution, we should absolutely take that approach. Whether they deem it to be severable or not, that remains to be seen. From our perspective with Right on Healthcare, we're more interested in what we're going to be able to do, whichever direction we end up moving in.
Yeah, and we'll get to the policy implications here in a second. There was some really strange talk. I mean, only arguments that lawyers could love about how, because even though it was still law, even though we still had the mandates and the regulations, the fact that the penalties weren't enforceable meant that no one was injured. So you basically have a zombie law that is still on the books, but it's, because it's not enforceable, it technically is not a penalty or a punishment. Very strange. How do you think, just kind of read the tea leaves for us a little bit, Rob, quickly. How do you think the justices will score on the two major questions on the case today?
It was bizarre. It was bizarre to me that the Solicitor General for the state of California and the attorney for the House of Representatives, the Congress of the United States, would get up there and say, don't worry about what the federal law says. You can just ignore that. The American people can just ignore the federal law if you're not going to get punished for it. I mean, that just seemed to be an incredible position to be taking in front of the United States Supreme Court, whose job it is to interpret law. So I really don't think that is going to, go very far. Even more so because the Supreme Court already analyzed that provision in 2012, and a provision in 2012 that at the time didn't have a penalty because the penalty hadn't gone into effect yet. And the mandate has always been a command to people to purchase insurance, even people that were outside of the scope of the penalty. So this no harm, no foul type argument is, I think, disingenuous to make that argument in a court of law. And it's just factually
justices are
untrue.
receptive to that argument? Did you get a feeling that they were pushing back, that a majority of the justices were pushing back on points like that?
Not a majority. I mean, I think the justices on the furthest left, I think, maybe it was Justice Breyer, Justice Kagan, we're trying to float out this kind of like no harm, no foul idea about law, but it really didn't seem to go anywhere. And, I think the court really wants to get to the merits of this case and isn't going to be tempted to take some kind of off ramp in saying that there's just not an injury, so we shouldn't decide the case.
Right. Well, far from no harm, no foul. Of course, Americans are seeing a lot of harm when it comes to their skyrocketing premiums and their deductibles, their tens of thousands of dollars in deductibles that they have to pay as a result of this law. So now kind of handicap it for us on the policy side, Dave. Either way that it goes, whether they invalidate the law and completely eliminate it, what happens to healthcare policy? What happens to people's insurance and healthcare if it does in fact get invalidated? And if it doesn't, if they figure out a way to uphold the law, then what's next for healthcare policy after that decision?
Depending on the decision, if it is invalidated, it'll go back to the initial court, where the judge will make a determination as to when the law will be phased out. If the decision is made in the spring, I would imagine that because there's an annual calendar year for the Obamacare exchanges, that at the very soonest, it would be at the end of 2021 and quite possibly 2022. Again, if it's invalidated, that really opens up a lot of flexibility during that phase out period to have the alternatives that have been suppressed during the existence of the ACA to really come and really be a part of the American fabric in healthcare, have new innovative types of coverage, have new innovative types of care delivery and things like that. So we have a lot that can and should be done.
So I want to get back to the justices real quick with you, Rob. The Chief Justice, Roberts, in particular, he's the one who wrote the opinion that saved Obamacare last time and this sort of contorted logic. Any sense that he was looking for a way to do a similar thing here with his line of questioning?
One thing that really stood out to me about the Chief Justice's questioning today is really how aggressively he went after the attorney for the House of Representatives. I mean, in 2010, 2012, the central concept was this individual mandate, when it was the same attorney at that time that argued on behalf of the United States government, that was arguing about how critically important this provision was, and who then showed up today and said, it's not that big a deal anymore. And it was the Chief Justice that kind of accused him of a bait and switch on that provision. But, I think it's going to be, it's a much different court than it was in 2012 and 2015. You now have a 5-vote block that excludes John Roberts. I mean, back then he was the 5th vote, but potentially Barrett, Kavanaugh, Gorsuch, Alito, and Thomas can decide this case without Chief Justice Roberts. So that's going to put that block in the driver's seat if they can hold together. And it'll remain to be seen if the Chief Justice joins with them, or if he would be put in his position to be in the minority, siding only with the liberals. So I really think that Justice Thomas, being the most senior conservative justice on the court, if he can pull together Justices Barrett and Kavanaugh, is the one who would really control the outcome of this case.
We would love to see an opinion by Thomas in the majority for sure. And just finally, quickly on the policy, specifically here in Texas. I mean, Texas has been a leader in at least looking at and innovating with healthcare reforms that might come to pass in case the law is invalidated. Can you talk a little bit about those efforts, and what should the Texas legislature and members be looking at, and what should they be preparing for the next session?
I'm going to say something that I say a lot of. When we're talking about the ACA, we're not talking about healthcare. This is a health insurance vehicle. When we talk about Medicaid, that is health insurance. What we want to focus on is providing healthcare to not only the most vulnerable in a safety net in the state of Texas, but we also want to be able to make healthcare more affordable again. The ACA created an environment where we have just astronomical, not only the premiums and the deductibles and the coinsurance amounts, but also just the price of healthcare alone, looking at the pricing in the hospital. So we want to look at transparency. We want to have entice and create an environment where physicians will come back into the state of Texas, have a focus on primary care, looking at enforcing some of the laws that we already have on the books, Corporate Practice of Medicine Act and some others. There's quite a bit that we can look at, whether the ACA is invalidated or not. If it is not invalidated and the ACA remains the law of the land, we can certainly have a lot of flexibility in a 1332 waiver.
So we won't get the decision probably until next spring or next summer. So we'll be patiently waiting to see what the Supreme Court decides. Dave Ballot, Rob Henneke, thank you for being with me today, and thank you for watching.
Thanks for joining us.